on manslaughter in the first degree.
No, in light of Engel and the corrections for Engel, no, I don't.
Okay. All right, does the state have any objections to my instruction on the elements of manslaughter in the first degree?
No, Your Honor, the record should just reflect that we had requested an instruction in line with the jury instruction guides as the controlling instruction. After talking it through with the court and counsel and chambers and relying on the language in State versus Engel, E-N-G-L-E, we would not object to the instruction as the court has worded it.
All right, and let's turn to the jury instruction on manslaughter in the second degree. Is there any objection to that instruction?
Yes, there is, Your Honor. We requested in our proposed instructions that you include a paragraph from State versus Frost defining culpable negligence, particularly the language in Frost, which quotes State versus Bolsinger, B-O-L-S-I-N-G-E-R. That's from 21 Northwest 2nd 480. It's a 1946 case. And the language we wanted you to include is as follows, quotes, it is more than, in defining culpable negligence, we wanted this language, quotes, it is more than ordinary negligence, it is more than gross negligence, it is gross negligence, coupled with the element of recklessness, it is intentional conduct, which the actor may not intend to be harmful, but which an ordinary and reasonably prudent man would recognize as involving a strong probability of injury to others. We believe that is the current culpable negligence definition in Minnesota. We don't believe it's been overruled by State versus Engel, and that it should be included specifically that first sentence that I've given to you.
And the state's response?
First of all, let me just backtrack a little bit. The previous instruction on the manslaughter one we had worked on quite a bit in chambers, and I indicated we did not have an objection as we believe it was formulated. I would just reserve the opportunity to address that instruction if once we see the final version that the court has. I think we got it all figured out, but
Okay.
just want to have that opportunity. The manslaughter 2, Your Honor, we oppose the requested instruction for a number of reasons, but we have no objection to the version as the court has provided it to us, and so we have no objection.
Okay, I just want to note that the version that is in the court's instruction is the standard JIG instruction. We discussed the fact that the instruction requested by the defense is not consistent with the present state of the law regarding the various mens rea necessary in homicide cases and would confuse the jury. We then talked about the affirmative defense, authorized use of deadly force by a police officer. We are going to finalize that instruction after some of the testimony is in. And Mr. Ng, you had an additional request for an instruction.
We also requested, Your Honor, the language from Minnesota Statute 609.06, which defines reasonable force that an officer can use in making an arrest. And the four elements of the reasonable force in that statute all apply to this case. They can make an arrest for a crime, for a warrant, for someone who's trying to escape. And the jury should be told that the officers involved, including Officer Potter, were acting under state authority to do what they did in making this arrest, or at least attempting to make this arrest. So we asked for that language out of the statute, again, 609.06.
Okay, Mr. Frank?
Your Honor, as we discussed, we do oppose that instruction as an affirmative defense. An affirmative defense serves to negate culpability or liability for conduct. What Ms. Potter did here was the use of deadly force by using a handgun to shoot a person in the chest and kill him. So it's not relevant. as an affirmative defense, whether Officer Potter at the time used non-deadly force as an affirmative defense. So we objected to that, and it's my understanding the court is, well, we did object to it, Your Honor.
Okay. Yes, I indicated that I was not inclined to give that instruction because in this case, there was deadly force used.
Could you take your mask off, Judge?
Oh, sure.
Thank you.
Yes, I ruled that I would not give that instruction because in this case, deadly force obviously was used. And I'm still going to be open to consider that. It's not my final decision. I'll have to see how the evidence comes in. Okay? All right. Is there anything else on the jury instructions that counsel wanted to note objections to?
Yes. I do have at least, we proposed a number of jury instructions before the trial began. The court has declined to give those, but I would like to make a record of our objections to your decisions in all due respect. The first one was, we asked for an instruction defining flight of a police officer as a felony. This is consistent with the Minnesota statutes, particularly section 609.457, subdivision 3. Several years ago, the legislature amended the flight from the police officer statute to make it a felony, especially if it's in a car. And it's also considered a violent crime. It's a crime of violence that Mr. Wright committed here. And we've asked for an instruction to define flight from the police officer as a violent crime, citing the statute and also Sykes versus United States, SYKES versus United States. That's 131 Supreme Court 2267 at 2273, 2011 case. I cited the U.S. citation in other briefs to the court. But in that case, the Supreme Court discussed fleeing a police officer in a vehicle and described in great detail on why it was so violent. And it directly applies here because Mr. Wright's conduct was exceedingly violent, more than dangerous to the police, and could have killed the police officers had they not stepped back right away upon hearing taser, taser, taser. And so we believe that the instruction buttresses the requirements of 609.066 and that the officers can use a reasonable use of force, if not deadly force, to prevent a crime of violence of this kind. So we request that we still request that you include an instruction to that effect.
Okay, Mr. Frank, did you want to be heard?
All right, we did object to those several definitions there. Fleeing is not always a felony. Fleeing in a vehicle maybe, but regardless, it's inappropriate for the court to define it in the way requested by defendants, or by the defendant. The particular reliance on the United States Supreme Court case, Sykes, is completely misplaced. That is a case that deals with interpretation of a federal statute, the Armed Career Criminal Offender something, and so has no application or precedential value here, and would certainly be the court also giving an instruction on emphasizing one particular piece of evidence and trying, as defendant is continuing to try to have their closing argument put into the jury instructions. So for those reasons, we did object to any of these definitional instructions being put in.
And I denied that instruction as well. You know, obviously there will be police officers testifying, and they'll be able to state that this is a crime of violence. All right. Is there anything else?
We requested a reasonable use of force definition taken from Graham, Graham versus Connor, 490 U.S. 386 at 396. That's a 1989 decision of the Supreme Court that defines what reasonable use of force means. In particular, it means that it's not evaluated by 20/20 hindsight, it's considered by the officer's objective reasonableness at the scene, and it notes, the definition does, that these circumstances that we will see in this case are, quotes, tense, uncertain, and rapidly evolving. And this is the classic definition of reasonable force and how to evaluate it by the Supreme Court. It's been given in at least 2 other manslaughter cases that we know of, the Crook case and the Giannis case, and should be given here.
Mr. Frank?
Your Honor, we did object to this. As the court knows, the court will be giving an instruction on the use of force that talks about the totality of circumstances known to the officer, so the existing instructions incorporate the law appropriately. This instruction is not appropriate to give for 2 basic reasons, one of which is this language does not it was not intended to define reasonable force for criminal cases here. The language comes from appellate decisions in which courts are reviewing immunity claims in Section 1983 cases. It's very good language for appellate arguments and decisions, but it has no place in necessary place in instructing a jury, as the instruction, as I said, already encompasses that. In addition, this would have the purpose of calling out certain pieces of evidence and playing into a defendant's claim. Trying to get the court's imprimatur of authority on these particular facts is more important. So for these reasons, we objected to the jury instruction.
All right, I'm going to use the standard instruction, and I believe the standard instruction does incorporate that thought, because it states that to determine whether the actions of the police officer were necessary, you must look at all facts known to the officer at the precise moment she acted with force. Obviously, the police officers that are testifying can testify to that principle. I would not preclude that at all. All right, Mr. Ng?
Relatedly, the court has declined our examples of what is reasonable and unreasonable conduct. We submit that on the record, but we do note our objection. The next instruction that the court has finding again is the collective knowledge doctrine instruction after State versus Conaway, CONOWAY, 319 Northwest 2nd 35 at page 40 and 19 case of the Minnesota Supreme Court, which held that, in making an arrest, the collective knowledge of the police officers on the scene is imputed onto each officer, and this is important for us because the expert for the government or state indicates that Officer Potter could not have known or did not know what was occurring to another officer, Officer Johnson, who was in grave danger here inside the car, trying to make sure it didn't drive away. And under this doctrine, she had knowledge as a matter of law.
All right, and I already ruled on that. I stated that the collective knowledge doctrine really pertains to establishment of probable cause. In other words, the collective knowledge of the officers, even though one officer may not know of one particular fact, their entire knowledge is imputed to determine whether or not a particular situation established probable cause to arrest or otherwise. So I will not give that instruction.
We also object to the court's ruling that our instruction as to whether or not the officers were authorized to make an arrest under the warrant here was permitted by Minnesota Statute 629.30, and that they didn't have to have an arrest warrant in hand. So we do object, and I also relatedly set forth in our proposed jury instructions examples of the negligence of Mr. Wright. The negligence that he had in this case has to be considered by the jury under State versus Crice, CRACE, 289 Northwest 2nd, 54, Note 5. It's at Note 5, 1979 case. And the examples of his negligence that we want instructions is that he didn't follow police orders, he engaged in unreasonable flight, he had marijuana, the odor of marijuana in his car, he had no license, and his conduct contributed, his own negligence was unreasonable. His conduct was unreasonable. His own negligence contributed to the tragedy here. We object to the court's ruling, which I anticipate you'll set on the record, denying our request.
All right. And all of those allegations of what Mr. Wright should or should not have done can come out during testimony. They don't belong in the instructions. Any reference to Mr. Wright's negligence would only tend to confuse the jury. But the defense, of course, can argue it. As far as the warrant is concerned, again, counsel is entitled to get testimony in that a warrant, even though the officers didn't have the warrant in hand, and entitled them to arrest Mr. Wright. Is there anything further, counsel?
Well, just two things. Number one, Mr. Gray and I have reviewed all the exhibits from the state, and we have noted for the court's review about 10 exhibits, and we consent to the court's in-camera review of those 10 exhibits under 403 analysis. We believe the prejudicial impact will far exceed the probative value, and we rely on the court to make that analysis without further argument. And then finally, we, in response to the spark of life testimony that may be coming in the case, we sought to offer or attempt to offer a picture of Mr. Wright with a handgun pointed at a mirror. This would vitiate, in our view, the proposed testimony of his life, as it were. It does indicate an extreme amount of violence. The court has decided not to admit that picture. We will make a court exhibit for the record. We do note our objection.
Okay. Anything else from Mr. Ng or Mr. Gray?
No.
Anything further from Mr. Frank?
Yeah, I would just note that there were, I think, 4 different instructions that Mr. Ng noted as objections to the court not giving or including, and just for the record, the state did object to each of those instructions requested. I think it's very apparent that some of those instructions are meant to just make arguments today for the public, and also to have the court sign on to those arguments for the jury. So one of the reasons that they're improper as jury instructions. We understand that the defendant will not make any foundational objections to the exhibits we have noticed for the defense and provided to the defense, and they have provided us with a list of exhibits that they have other really relevance-based objections to, or 403 objections to. We will be looking at those and providing a response in some form to the court that will probably expedite resolution of that.
Okay, we did have some discussions about proposed character evidence with respect to Officer Potter. And just for the record, can you please summarize, defense counsel could summarize the type of evidence that you wanted in with respect to character evidence?
We'll be offering evidence of Officer Potter's reputation for peacefulness, for honesty, and for being law-abiding. This evidence will come in from lay witnesses and her fellow police officers as well.
Mr. Frank?
Thank you, Your Honor. As you know, we have filed a memo on this. The character for honesty is something the court cannot address until her credibility is directly challenged, and even then would be limited in scope. The general character evidence, we don't believe that any pertinent character trait exists that would allow any character evidence other than reputation or opinion evidence regarding law abiding as sort of the defendant's kind of catch-all. But that should be very limited, Your Honor. This is not a trial about Ms. Potter's general character, and there should not be any extrinsic evidence. There should be opinion only about that, and it should be limited to just that.
Okay. The rules of evidence allow admission of character evidence if offered by the accused. And the two matters, being peaceful and law-abiding, I believe are appropriate matters for character evidence. Because of the charges here. They do pertain to the charges here. I will not allow evidence concerning specific instances of good conduct, but I will allow it. Okay, anything further on the record before I address the autopsy photos?
On the exhibits, you do stipulate the foundation. We need to make a record with our client that she agrees. We believe she will agree.
Oh, yes. You wanted to you want to put on the record that your client has waived her appearance here?
She's, Your Honor, we've discussed this in detail with Officer Potter. She waives her right to be here. She does waive that right knowingly, voluntarily, and willfully, and we'll make a record on Wednesday morning of that effect.
Okay. All right. Now, there will be a number of autopsy photographs of the deceased, and out of respect for the deceased and the wishes of the Wright family, I've ordered that the photos be shown without live streaming. Again, I want to emphasize that this is not a courtroom closure. The general public and the media that are in the courtroom will not be asked to leave. The media and the public will have the overflow courtrooms to view those photographs on the closed circuit TV. And the requirements under Waller have been met. First, the overriding interest here is the respect for the family's wishes and the deceased. Second, the closure, if there is one, is no broader than necessary. That overflow courtrooms will remain open and running. Third, I find this way of proceeding is the most reasonable manner to deal with the situation at hand. I further find it strikes a fair balance to the right to a public trial and the family's interest in maintaining the dignity of the deceased. Okay. All right, counsel, is there anything further we should put on the record?
No, yeah.
All right. It looks like we're going to not be in session at all tomorrow. If something should come up that you would like to put on the record, please give my chambers a call, okay? Do you anticipate having anything come up tomorrow?
No.
Okay. Well, it's good to have a prep day. All right. Okay, counsel, have a good rest of the day, and we will see you on Wednesday morning at 9 o'clock.